All right, it is March 26, 2025. We are in the midst of a Canadian election, and we have some upcoming episodes about that, but that is not what we are talking about today. Today, we are talking about a Supreme Court of Canada decision that came out on March 14 that doesn't strictly pertain to immigration, but the dissent and some of the interveners raised how it could be extended, the principle in it, to apply to Canadian immigration. And it kind of ties together some of the things that we've been talking about on
How
the
it
show.
should be extended to immigration, I think, perhaps.
Should be Indiana's take. It'll be, I don't actually know fully where I come down yet, although I do
Yeah.
think that I lean towards you, because as soon as I start thinking of examples, I do think that at least some parts should extend to immigration. The Supreme Court of Canada decision is John Howard Society of Saskatchewan v. Saskatchewan. And what this is about is the presumption of innocence and the standard of review in, I guess for lack of better word, prison law matters. Section 11D of the Charter guarantees that all persons who are charged with an offense are presumed innocent until they are proven guilty. The presumption here of guilt requires to be proven beyond a reasonable doubt. I think everyone listening is probably aware of those two concepts, right? You're innocent until proven guilty. That's a maxim that everyone knows, and that in the criminal context, to be convicted, they have to be satisfied that a crime was committed beyond a reasonable doubt. A part of this, and what we've sort of talked about in previous episodes, was we had that episode on risk salience in the refugee determination context with Hillary Evans. And we talked there about the maxim, how in the criminal context, there's that general notion that it's better that 5 guilty people go free than 1 innocent person go to jail. And we discussed how if there is a similar context in the refugee determination process, which there isn't, and also whether there should be. As a bit of a side note, as far as the innocence until proven guilty concept, I was with my family in Kingston last year, and we were driving past a prison, and my son had just turned 6, and I asked him about this maxim. Like, would you rather that 5 guilty people go free, or that 1 innocent person has to go to prison? And my son, who had just turned 6, said that he would like that the 5 guilty people go free, but that he would then want to go to prison because he wouldn't want to be out on the streets while those 5 guilty people were out there, which I thought was just a very neat take. Anyways, in getting to the decision, which we will
and the other standard, maybe we should explain too that the other standard of proof, which is the one that was actually being tested, was the balance of probabilities, because the actual case turns on a piece of legislation that deals with disciplinary proceedings for inmates, where the disciplinary measures can become a penalty where it is established on a balance of probabilities that they are guilty of that offense. And so the balance of probabilities is a lower standard. It's the civil standard, which is lower than the beyond a reasonable doubt, because it doesn't rise to the same level where you need to show beyond all reasonable doubt. It's more like I don't know, how would you describe the balance of probabilities test, Steve?
I was hoping to leave that to you. The difference between beyond a reasonable doubt, balance of probabilities, and reasonableness, which is what is in the immigration context.
Right.
Basically, beyond a reasonable doubt means that you have to be very, very sure that someone did something and that there's no reasonable doubts in your mind that a crime was committed. It's a very complicated topic. Like, I listened to a U.S. criminal defense podcast where he gets into how whole cases and appeals can be based on whether the jury was properly instructed as to whether the beyond a reasonable doubt standard was properly articulated by the judge. But that's basically it. You have to be very, very certain.
Yeah.
Balance of
Innocent until proven
probabilities is
guilty.
just, you flip a coin, and as long as it's more likely than not that it happened,
More
it's
likely
more
than not.
probable than not that it happened. That's the standard. And then reasonableness is just, if you look at it and you could get to that conclusion, it's reasonably, then that's the reasonableness standard.
And with reasonableness, there's always this element of deference. Like if the original decision maker found that there was a rational basis to uphold that finding, if it's reasonable, then the court generally will not intervene unless you can show, according to the standards set out in Vavilov, that there was some leap in logic, there was some error in the reasoning, or that the decision was wholly not based on the facts that were before the decision maker. So it's the most deferential and the one that requires the lowest standard of proof.
And so in this case, as you were saying, Deanna, it involved how people in the Saskatchewan provincial correctional institutions who were charged with disciplinary offenses, the standard of proof there was a balance of probabilities. It wasn't beyond a reasonable doubt. And so the John Howard Society challenged, and what the Supreme Court had to look at was whether the beyond a reasonable doubt presumption, or Section 7 of the Charter, would apply to these disciplinary proceedings. So they aren't criminal proceedings. Someone has breached some term of their being in the Saskatchewan Correctional Institution. It's not a criminal charge, but should some of the criminal law protections and charter protections apply? And the Supreme Court determined that the charter protections of the presumption of innocence, as well as Section 7 of the Charter, should apply. And so just to read a little bit from the heading of the Supreme Court decision, which we'll link to in the show notes, Section 11D of the Charter guarantees all persons charged with an offense the right to be presumed innocent until proven guilty. This presumption requires guilt to be proven beyond a reasonable doubt. Under the test, and I'm still reading from the heading, quote, under the tests articulated in R.V. Wigglesworth, Section 11 applies to a person charged with an offense when proceedings are criminal in nature or lead to the imposition of true penal consequences. The criminal in nature test focuses on the purpose and features of the proceedings themselves and not on the underlying acts that give rise to the proceedings.
Yeah, this part of the discussion is very, very interesting because the way that it talks about what renders something to be a criminal, a proceeding that is criminal in intent, regardless of whether or not it comes from a criminal statute. And it's a very interesting discussion about a decision, a public function that signals, and this is at paragraph 89, that signals moral and social disapproval of certain behaviors. So it's a much broader definition, not strictly that it's a term of imprisonment or that it emanates from a criminal statute, but more that it is a sort of a something that is a government rendered decision that goes to the point of casting a moral determination based on some kind of wrongdoing.
Exactly. And the court also notes, that when the concept of imprisonment is defined by references to substantive attributes rather than unduly fixating on the form like imprison, that it can go beyond just being in prison. So imprisonment, as the court notes under, still in the heading, true penal consequence, includes state-imposed sanctions that, in light of their attributes, represent a deprivation of liberty at least as severe as that resulting from an initial sentence of imprisonment, and that courts can also consider the fact that sentences of imprisonment can include non-carceral punishments that share the fundamental features of significantly curtailing an individual's freedom of movement and segregating them from others.
Mm.
You kind of see where we're starting to go with this, right? Like curtailing an individual's freedom of movement. That is at its core what immigration law is about. Segregating them from others, family separation. And then, as I think Deanna noted, that the court also found in the Section 7 context that in proceedings where a moral judgment is made and there are severe liberty depriving consequences that are imposed as punishment, then Section 7 of the Charter requires that the standard be proof beyond a reasonable doubt. Before we get into the dissent and the immigration consequences of this, or potential consequences, is there anything you'd want to add about what the majority found?
I don't think so. No, I mean, I think no. I think I'll leave it there. Yeah.
Okay, so let's skip down to the dissent. The majority doesn't talk about immigration consequences at all. But if we just scroll down to the dissent, this was a 6-3 decision. I will quote. So the dissent raises all sorts of, okay, well, if the people who are getting administratively punished in the prison context have the right to a standard of beyond a reasonable doubt, what about other areas of the law? And paragraph 253 of the dissent states, quote, another example of the far-reaching impact of this line of reasoning can be seen in the immigration context, which is by its very nature administrative, not criminal. For example, Division 4 of Part 1 of the Immigration and Refugee Protection Act sets out rules of inadmissibility for permanent residents and foreign nationals. Specifically, Section 36, Sub 1 sets out the grounds on which a permanent resident or a foreign national is inadmissible for serious criminality, including when he or she has committed an act outside Canada that is an offence in the place where it was committed, and that, if it was committed in Canada, would constitute an offence under an Act of Parliament punishable by a maximum term of imprisonment of at least 10 years. The Immigration and Refugee Protection Act sets out that the determination of whether a permanent resident has committed an act described in Section 36 is to be based on a balance of probabilities. It is conceivable that such a non-criminal administrative proceeding could attract the application of Section 7's presumption of innocence, because there is both a moral wrong, the violation of immigration law, or the underlying serious criminality itself, and severe liberty deprivation, being deportation or inadmission. This extension of the residual presumption of innocence to non-criminal administrative proceedings surely was not complicated or contemplated by Pearson, a prior case. End quote. And before we get to discussion on the principle and where this may apply in immigration law, because I'm sure that there is going to be challenges now raised on this, some of the factums by different government interveners and the respondent raised this as well. So this is from the factum from the Saskatchewan government, which noted in objecting to expanding the beyond a reasonable doubt standard that, quote, many administrative frameworks potentially restrict liberty. Immigration authorities may detain, arrest, or remove from Canada admissible. Similarly, Ontario noted that immigration proceedings do not require a judicial process or reasonable bail where the person may be deported to torture. The Canadian government, of course, probably the most alert to immigration issues, similarly said that in the many state actions outside of the correction context also potentially engage Section 7 interests, yet do not require proof beyond a reasonable doubt. Examples include immigration certificates and immigration detention. And finally, the last intervener that I'll mention before we get into a discussion on all the different ways where immigration law may benefit or could be impacted by this was the Alberta government, which when they intervened wrote, penalties such as deportation or indefinite detention in the immigration context loss of the ability to practice one's profession in the regulatory context, loss of custody in children, or bankruptcy may all involve more serious outcomes to an individual than those resulting from some criminal proceedings. However, it is the unique nature of the stigmatization of a criminal's conviction, the accompanying moral condemnation, and the public nature of seeking redress for a wrong done to society that underpin the constitutional necessity of the reasonable doubt standard. Administrative proceedings concerned with discipline and regulation are of a fundamentally different nature. End quote. And I think that is the perfect place to springboard into our discussion of immigration, because there are, as the government's noted, many areas in immigration where the reasonable doubt standard could apply. And I think obviously the conversation may flow where it flows, but I think it would be interesting to first show what some of those are, or explain what some of those are. And then I'm really interested in this question that we were talking about before we started recording of, given the consequences that we're going to outline in the immigration sphere, does it make sense that it is this stigmatization in the criminal context that is determinative of whether the presumption of innocence should apply, or should it be based on these consequences? So maybe, Deanna, do you want to go through or highlight some areas in the Immigration and Refugee Protection Act that have severe consequences for individuals with a lower standard than beyond a reasonable doubt?
Oh yeah, there are so many. I mean, when you look at any proceeding before the Immigration Division, where the department is attempting to establish that the person is inadmissible, generally speaking, those admissibility findings need to be established on the civil standard, so reasonable grounds to believe. So if they're trying to establish that somebody is inadmissible for criminality, serious criminality, organized criminality, as well as the security concerns that are at sections, I think, 34 and 35 of the Act. In all of those cases, when the department is trying to establish that the admissibility lies, they will be demonstrating that on the reasonable ground standard. So it is a low bar. And if they are able to make their case, generally there is no ability at the Immigration Division to bring equitable arguments to explain why that there's no relief, essentially. There's no mitigating factors that get considered in there. And then generally, if the admissibility is found, a removal order will be the necessary consequence of that.
Automatic.
Yeah.
And the standard is like for Section 33 of the Act provides that for the most serious inadmissibilities, whether someone is a terrorist, whether they're inadmissible for espionage, that the standard is facts for which there are reasonable grounds to believe have occurred. And the consequence of being found inadmissible to Canada for any of those security concerns is a lifetime ban on entering Canada, right? That restriction of movement that was sort of highlighted in the case. A lifetime ban from Canada, the possibility of family separation is all completely automatic.
And we've talked in previous episodes too about the very serious nature of that, particularly given that the department is able to look at potential future risks as opposed to actual, where there's evidence that they can actually rely on as a basis for concluding that a person is or has committed an act of terrorism. If they're just simply assessed as having the potential future risk, it is quite an unclear standard for which somebody would have this lifetime prohibition that arises.
Oh, I mean, look at the Lee decision, how different that is if there's a different standard. So the Lee decision found, the Chief Justice found that under an expanded definition of espionage, it is reasonable to believe that someone from mainland China who has a highly skilled background may be coerced into going back to China and divulging things that they learned in Canada, and that would constitute espionage.
Not based on any activity that they had actually done that was contrary to any law or policy, but strictly because of their high degree of specialized skill and education.
Yeah, and the consequence to Mr. Lee is a lifetime ban on entering Canada. That decision goes very different under a standard of beyond a reasonable doubt.
For sure.
That decision just doesn't get reached if the standard is beyond a reasonable doubt.
No, for sure.
Other examples where it comes up in the organized crime context, which is also so a permanent resident or a foreign national is inadmissible on the grounds of organized criminality if it's reasonable to believe that they have taken part in a group of 3 or more people, essentially, that have engaged or will engage in acts of crime. I've seen, and I'm sure you've seen, cases where individuals have dismissed or stayed charges, or even if they are charged and convicted in the criminal context, the consequence, could be a conditional sentence, could be a discharge. And then using the reasonable standards test in the immigration context, it is again a lifetime ban on entering Canada.
The thing, suffice it to say that beyond a reasonable doubt does not exist anywhere in the immigration context, in no proceeding. I don't think I'm overstating it when I say that.
No, everything's based on either balance of probabilities on the high end or the reasonableness standard.
Far more frequently, it's
even for smaller things like the non-discretion in how long the length of a misrepresentation bar should be, of being an automatic 5 years, where there's all sorts of, it's all based on the sufficiency of evidence before the officer. They need to be satisfied as to whether on a balance of probabilities a misrep occurred. That again is very different and beyond a reasonable doubt with these huge consequences.
I'm also I'm encountering, and I've been talking about this a fair bit on the podcast, a number of situations involving people who have been asked to produce documents for the department and then have alleged and have established in their judicial review applications, to some degree at least, that they did not receive that communication. Again, the federal court will be looking strictly at whether or not they had reasonable grounds to believe, the officer had reasonable grounds to believe that they received it and that they did not receive that communication and that they then fell out of status and are no longer eligible. Again, that could have a permanent consequence in the sense that, they're they no longer have an opportunity to do what they were intending to do before. Again, whether or not that would be defined as having some kind of quasi-criminal kind of implication, I think is something different. But again, just showing how low the standard is that is being applied when people's, long-term consequences are being evaluated is at this very low standard, just across the board in the immigration context.
Yeah.
The other thing I wanted to say, though, about this question of kind of moral turpitude is that when you're dealing with removal order proceedings, appeals before the Immigration Appeal Division, the Ribic test, like when you're going through whether or not there are sufficient grounds, because the Immigration Appeal Division does have the ability to overlook an inadmissibility, in a residency obligation appeal or even in a certain types of admissibility finding, where you can establish that there are sufficient humanitarian and compassionate factors. But what I find very interesting about this is that in a lot of those cases, one of the factors that the board will consider is the severity of the offense that is under consideration. And in those decisions, you very often hear words like about the moral turpitude and whether or not this was a very serious or egregious type of a crime. And so, again, when you read the wording in the in this decision here, you do get that sense that of the proximity between this kind of quasi-criminal consequences, where they'll say, this is, that the department is trying to protect the interests of Canadians. Like, it does have all of these stigmatization, inferences that you would find in the criminal context, and consequences that flow from those.
Yeah, and these are sort of going back to the issue we raised at the start and the issue that I'm really curious about, and I'd love to hear from any criminal defense lawyers, for example. And Peter Edelman, when he was recording with us, used to say when we would raise this issue, well, there's the stigmatization in the criminal code context, which, I'll be honest, I don't fully get, because, yeah, I mean, it's stigmatizing to have a criminal record, but to me, the consequences would be way more important to me. Like, if I had to choose between let's say there's two proceedings for, I don't know, theft over, and one is that someone has a criminal record for theft, but in the criminal process, because of the standard of beyond a reasonable doubt, they'll get, say, a plea bargain where they will get a conditional sentence of like a day, or released shortly thereafter, or house arrest or community service, versus for the same offense, no criminal record, but because it equates to serious crim, would be ban on entering Canada and deportation. I would much rather have the criminal record than the ban on entering Canada. And to
For
me,
sure.
it seems like the same protections should apply, and that the protection should follow the consequences at least as much as that stigmatization.
For
I'm
sure,
prepared to
particularly
hear
where
the
you have
counter arguments. I haven't heard the counter argument presented in a way that's convincing to me yet on why the consequences should not be given as much weight as the stigmatization of a criminal record.
Yeah. I mean, particularly when you think that the person concerned might have spent the majority of their life living in Canada. They might have family here. Their establishment might be quite significant.
Mm-hmm. So we'll see. That's about all I have on this short episode on this decision. I am sure that as a result of it, there will be charter challenges on various aspects of the Canadian immigration system, which is why we talked about it today, to sort of bring it to people's attention and also raise this issue. So awesome then. Unless there's anything else, we will wrap up, and another episode on Friday. As I said, there's going to be a fair number of election-related episodes coming up, so we will see you soon.